everyone, and welcome to the Bonavero Institute of Human Rights. Welcome to those who are joining us in this very rainy, dark, cold day in Oxford, and also welcome to those who are joining us online via this webinar. My name is Başak Çalı. I'm the head of research here at the Bonavero Institute, and I will be chairing this book discussion this evening. And I'm very delighted to welcome Professor Vladislava Stoyanova today. We are going to be discussing her very recently published book, and let me hold it as well so you can see it. It has a beautiful cover, and I'll be very happy to put it up as well. And it's entitled Positive Obligations under the European Convention on Human Rights Within and Beyond Boundaries. So we're very excited and very happy to have you. And as I understand, you started writing this book here in this institute, Vladislava. So it's wonderful to see that someone who's come here as a visiting fellow to the institute with an idea and started writing it, and then welcoming you back here with the book is absolutely fantastic. So very big congratulations on this piece of work. So we are going to do a few things today. We will first hear a little bit about the book, what the book is about and what it's seeking to achieve from Vladislava. And then we're going to have some interventions, reflections on the book by our discussants. So let me very, very briefly give you the order and the names and the affiliations of our discussants so that we can actually start getting into the substantive discussion as quickly as possible. And I'll introduce them in the order that they will be speaking following Professor Stoyanova's intervention. So our first intervention will come from Professor Sandy Steele, and he's a professor of law and philosophy in the Faculty of Law at Oxford. And in his work, he's interested in many legal and philosophical questions, but amongst other, causation is one of the areas that he's very interested in. And I think we will also hear a little bit more about positive obligations and causation and his reflections on the book. This will be followed by an intervention by Helen Mountfield. I always want to say QC, but I have to say KC. It's just a bad habit. He's a KC. And of course, she is also the principal of Mansfield College. So we're delighted to have you in the Bonavero, who is, for our webinar listeners, is also physically in Mansfield College, if you don't know the geography of the institute. And Helen is also a leading barrister specializing in constitutional law, in human rights law, and in equality law. So we're very happy to have you for this intervention. And finally, we're going to listen reactions to the book from Professor Ed Bates, who's at the University of Leicester, and he's a leading scholar of European human rights law and the case law of the European Court of Human Rights. And he has been working both on the history of the travaux préparatoire and also the wide-ranging case law of the European Court of Human Rights. So it's wonderful to have you, Ed, here to be able to comment on the book as well. This is a huge achievement. You will see in the introduction. And of course, one of the wonderful things maybe about the book is that it's open access. You can actually click on the university's, Oxford University Press's website and read the book, and what a delight. So I think it's wonderful that we're having more and more open access books in this context. And of course, one of the things about the book is that the positive obligations case law of the European Court of Human Rights is incredibly broad. It's incredibly complex and perhaps incomplete in many aspects, both doctrinal and philosophical. And in this very impressive piece of work, Professor Stoyanova Vladislava is taking on this incredibly courageous and ambitious task of trying to read a little bit of sense and systematization into this case law. And I think this is a very, very important achievement as such, and I'm really looking forward to discussing the book with her and also with our wonderful panelists. So over to you for your opening remarks, Vladislava. Please come onto the stage.
Well, first, it's wonderful to be back in Oxford. Many of the arguments in the book and the parts in the book, especially the last chapter in the book, were written during my time in the beginning in 2018 when I was a visiting researcher here at the Bonavero Institute. And I remember I was sitting in the reading room together at that time with Sir Nicholas Blake. And both of us were extremely focused on our work. And I think we both were extremely productive, but every once in a while, we went together for tea and coffee to cheer up. And it was very easy to cheer up with Sir Nicholas Blake. So I had extremely productive time in the beginning of 2018 and also very enjoyable in terms of social interactions. And now when I came back to the Institute, I saw the reading room is much more populated with much more people than what it was to be in the beginning of 2018. I would like, first of all, to wholeheartedly thank Professor Kate O'Regan for making this event possible. I'm very grateful to all the commentators for agreeing to engage with the topic of positive obligations, and also to Professor Bashak Charlie for sharing. And I'm very happy that I finally meet you in person. So in very simple terms, the objectives of this book have been to understand and to explain the standards that the European Court of Human Rights applies when it adjudicates positive obligations under the Convention. So in this sense, it is an effort to reconstruct the case law. The case law, which as already Bashak said, it's very rich. So that the relevant standards that have been developed by the court can be placed in some framework of analysis that makes them more understandable and perhaps easier to navigate. So in this sense, the work can be characterized as descriptive and also analytical. So positive obligations means the state is under the obligation to do something, to take measures to prevent harm or address harm. And an applicant before the court formulates an argument that the respondent state should be found responsible, internationally responsible under the European Convention of Human Rights for omissions. And if we look at the case law, various spheres from different aspects of our lives have been adjudicated before the European Court of Human Rights as possibly involving breaches of positive obligations. Let me just give you some examples to illustrate the richness of the case law. Such obligations are relevant, for example, when social service departments decide not to take children into care, children who might be exposed to unhealthy or violent family environment. There is a cluster of cases before the court that can be generally described as medical negligence cases. There is also another group of cases that can be characterized as cases of domestic violence. Positive obligations have been also relevant when state authorities, for example, fail arguably to ensure the safety of public places. When people are harmed due to natural disasters or due to industrial activities. So these are simply some examples. And the immediate cause of harm is not an act of the state, but an argument is formulated that the state should be responsible for omissions. And it can be rather unclear under which circumstances positive obligations may be triggered and how far-reaching they may be, given the difficulties of drawing state responsibility for omissions. And the objective of the book has been to address this challenge by identifying the key analytical issues that need to be tackled in determining whether a state should be responsible for those omissions. And these key analytical issues are identified from the case law and from the reasoning of the European Court of Human Rights. So in terms of analytical issues, we need to distinguish these three questions: the trigger of the positive obligation, then the content of the obligation, and then the scope of the obligation. My understanding from the case law is that in relationship to Article 2, the right to life, and Article 3, the right not to be subjected to torture, inhumane, and degrading treatment, the starting point of the court is that, as a matter of principle, the state is all the time under this very abstract and general positive obligation to prevent harm. And this can be illustrated from this quotation from Kurt versus Austria, which is currently the leading cases in the area of domestic violence. The first sentence of Article 2 enjoins the state not only to refrain from the intentional and unlawful taking of life, but also to take appropriate steps to safeguard the life of those within its jurisdiction. So this is framed in very general terms. The approach under Article 8, which is the right to private and family life, has been a little bit different, because here the court can engage in this initially with this initial appreciation whether there should be a positive obligation to start with, and this can be related to the very wide definitional scope of Article 8. Private life has been interpreted extremely widely. This abstract positive obligation, however, to prevent harm or to prevent the risk of harm, or sometimes the court talks about mitigating the risk of harm, needs to be specified in light of the concrete case. And specification will mean identification of some more concrete measures that the state should have arguably taken as counterparts to these omissions. So the content of the obligation refers to these more concrete measures. So this abstract positive obligation needs to be concretized somehow by identifying and specifying some more concrete measures that could have been taken at the relevant point in time. While the scope of the obligation will refer to the question how far-reaching these measures should be. And overall, in the book, this question of specification of the obligations is quite key. How does the court identify and specify the measures that should arguably form the content of the obligation? And these questions of the trigger of the obligation, the content, the scope, and also the question whether the obligation is found breached are decided with reference to certain standards that can be identified in the case law. And these standards are knowledge, state knowledge, knowledge of the state, the standard of causation, and the standard of reasonableness. And I would like to talk briefly about each one of them. So the European Court of Human Rights has been relatively consistent to the effect that for a positive obligation to arise in the specific context, it needs to be demonstrated that the state knew or ought to have known about harm or the risk of harm. So here the court refers to two alternatives: actual knowledge, the state knew or ought to have known, which can be framed as putative knowledge, and these are given as alternatives. And the standard of ought to have known, or sometimes the court formulates it should have known, the state should have known about harm or the risk of harm. So this standard is quite unclear. And it's possible to answer it's possible to approach this question of putative knowledge in at least three ways. And all of these three ways actually can be identified in the case law. So one possible way to approach this question of putative knowledge is to ask whether the harm was objectively and scientifically foreseeable at the relevant point in time, so that it can be concluded that the state authorities should have known about the risk of harm. And this is the standard that the court applies in some judgments. Now, the problem with this approach is that very often there is inconclusive scientific evidence, and in this sense, not really an objective standard that the court can use. Another way to approach the standard of putative knowledge will be to ask, would the state authorities have correctly assessed the risk of harm based on information that they could have had if they have engaged in something like risk assessment, or if they had asked for studies? So this will imply some kind of a initial procedural obligation of risk assessment. And this is the approach that has been applied in some cases. And I would say after Kurt versus Austria, it's very clear that in the area of domestic violence, the court has formulated such kind of an obligation of conducting risk assessment when there is an indication that of violent situation, the state authorities will be under the obligation to do risk assessment. Another third way to approach the standard of punitive knowledge will be to ask whether the state authorities should have known about the risk of harm based on the information that was actually available before them at the relevant point in the time, without engaging into the analysis what additional information the authorities could have had access to. And this approach can be identified in many judgments. The standard of ought to have known has been further obscured in the case law, because if we actually read the judgments and how the court reasons, sometimes it's very unclear at the end of the day whether the court determines that actually the state knew about the harm or the risk of harm, or whether the conclusion by the court is that the state should have known at the relevant time. And here I have an example from Onur Yurdiz versus Turkey, which is one of the leading cases in the area of positive obligations. I don't expect you to read the paragraph, but this is simply an illustration how, as a starting point, the court refers to these standards, but after reading the reasoning, it's not really clear which of these two conditions is actually fulfilled. And these obscurities surrounding the distinction between actual knowledge and punitive knowledge, or the standard of knew or ought to have known, relates to the fact that the state as an organizational entity does not have awareness to start with and cannot really know about things. And this standard of knowledge, at the end of the day, as I understand it, implies some normative judgments about how we organize ourselves and what kind of, as a community, as a political community, and what kind of risks we choose to identify as relevant, and how we make certain normative choices which risks to engage with. And I'll come back to that question of value-related assessments and normativity when I discuss also the standard of causation. So causation will imply that there is some link between the harm sustained by the applicant before the court, harm that falls within the definitional scope of one of the articles of the convention, and the alleged omission by the state. And it's normally the applicant that goes before the court and formulates the omissions and tries to argue that there is some linkage between the harm and the omission. And now what is clear from the case law is that the court has never formulated a causation standard or causation test. And not only that, but when I read the judgments, it's also, there is quite a lot of, it's quite also messy in terms of the different terms, the different concepts, different words that the court uses to express that idea of causation. And here I have some examples from O'Keefe versus Ireland, where the court said a failure to take reasonably available measures which could have had a real prospect of altering the outcome or mitigating the harm is sufficient to engage the responsibility of the state. So here the court refers to a test that it framed as a real prospect of altering the outcome or mitigating the harm. And I say that in the book, I say that real prospect seems to be a reasonable way for me to approach the standard of causation, but it's not consistently used in the case law. In other circumstances, the court uses other terms that you cannot see now, but let's say in other judgments, the court refers to ask the question whether the harm can be imputed, whether the harm can be attributed. So in this sense, there is not only uncertainty as to the standard of causation, but there is also quite a lot of uncertainty as to the different words and concepts that the court uses to express that idea of causation. What is clear, however, when it comes to causation is that the court has quite clearly rejected the so-called but-for test. And you can see this on the slide with the relevant references. The court has rejected such a test, which in any case, I think it will be very burdensome for the applicant to pass that standard of causation. And in this sense, that's a positive thing that the court has rejected the test. In terms of causation, what I would like also want to highlight is that similar to what I said in relationship to the standard of knowledge, the way the court approaches causation depends at the end of the day on value-related normative considerations about the role of the state in the political community, how the society chooses to live together, what type of risks do we choose to focus on. And the establishment of causation is also definitely made difficult because of certain empirical and epistemological uncertainties. And since the court might not want to see itself implicated in these normative judgments about the role of the state in the society, and since the court certainly does not have the tools to more generally engage with empirical evidence, it has crafted different techniques in its reasoning to avoid making judgments about causation. And I could identify at least two such techniques. One is domestic legality. And when I say legality, I use this in an extremely wide fashion. What I have in mind here is domestic regulatory framework, domestic regulations, even guidelines. And when the respondent state has failed to follow its own regulations and guidelines, it's relatively easy for the court to assume that these failures have caused the harm. And so the national regulatory framework in this sense is like a baseline, and any deviations from this baseline are viewed as suspicious by the court. And this is quite clear, from example, in a case like Taskin and other versus Turkey. And in this sense, the message from the Strasbourg court for the state here will be, well, state, you simply follow your own regulations and your own guidelines. Another technique for avoiding this difficult question surrounding causation between harm and omissions is the so-called focusing. The court chooses to focus on procedural guarantees. Instead of making any conclusions on the outcome, what it focuses on the national decision-making process and whether there was such a decision-making process and whether it was of sufficient quality. And now, finally, a few words on the standard of reasonableness. Because in every case adjudicated before the court that involves positive obligations, the court consistently says that positive obligations need to be interpreted in such a way as not to impose an excessive burden on the authorities, not to impose impossible and disproportionate burden. The court also refers to the standard of reasonable steps to prevent ill treatment. In the context of Article 8, my general conclusion was that the court doesn't really refer to reasonableness, but rather uses the fair balance test. And what the court has in mind when it refers to reasonableness is general public interests, including public policy considerations, budgetary concerns, cost effectiveness, management of resources, multiple other interests. It can also have in mind competing obligations, competing positive obligations, and including competing negative obligations. And it is difficult to frame all these priorities concretely in the context of the specific judgment. And often when the court refers to reasonableness, it's quite difficult to identify the concrete factors that the court takes into consideration at the end of the day to assess reasonableness and the different weight or importance attached to each factors. Very often we find at the end of the judgment the statement that it will not be unreasonable for the state to have done this and this. So and these are my final points, when it comes to reasonableness, reasonableness also has, as I understand it, at least two other functions in the reasoning of the court. One, which I frame as a technical function. It serves the function of ensuring flexibility in the application of a rule to a dynamic social reality. It enables the judges to present their decisions and motivations as being in line with the intentions of states, and to provide reasoning in the absence of a more precise criteria. In a way, it's a recognition that there is no one single solution. And also this is also reflected in one standard pronouncement that we can find in the judgment. The court consistently says that it's not our job, it's not the job of the court to say to the state what will be the best way for the state to fulfill its positive obligations. So what should be the concrete measure that the state should take or should have taken at the relevant point in time. And reasonableness, as I understand it, serves also this ideological function. The notion of reasonable is used in order to legitimize an assertion which by definition is subject to challenge, and in a way masks values that stand behind the judgment by elaborating a solution apparently based solely on reason. I'll stop here, and I'm looking forward to the comments. Thank you very much.
Thank you very much. This was a lot of introduction of the various analytical chapters of the book. So let me turn to the user and see who would like to start. You can sit here or you can take the
I might stay here, yeah. That's all right.
Thank you.
Okay, I'll preface this by saying I'm just a humble private lawyer, so forgive me in advance if I make terrible errors. But my comments on this excellent book are going to focus on chapter 3 on causation. And I'll group my comments into 4 parts. So the first part is going to be about the nature of this weaker standard of causation that Vladislava described in the presentation. And then I'm going to say something about the justification of that weaker standard. Thirdly, I'll say something about the mechanisms she describes in the book for avoiding causation questions. And then fourthly, I'll say something about limits to liability that go beyond causation but don't really relate to reasonableness or knowledge. Okay, so first off, the weaker standard of causation. One of the striking features of the law on causation in this context, or at least strands of it, for a private lawyer, is that the causal requirement of liability is relaxed in some way. So in ordinary private law claims for compensation for a breach of a duty, the default rule in common law systems is that the breach must satisfy a counterfactual test, the but-for test. So if the breach had not occurred, would the damage not have occurred? And in the common law, that's assessed on a balance of probabilities or ponderance of the evidence, normally cashed out as a greater than 50% probability that but for the breach, the outcome would have happened. It seems to be a higher standard in civil law jurisdictions, even in civil cases. It's described as standard of conviction in German law, anti-conviction in French law. But under the ECHR, it seems, as Vladislava explains, that so there's a quotation from this O'Keefe case which says a failure to take reasonably available measures could have had a real prospect of altering the outcome or mitigating the harm is sufficient to engage the responsibility of the state. And in another case, a Turkish case which is cited in the book, the court admits that no causal link may exist for the purposes of civil liability on page 57, and yet there's a sufficient link for the purposes of convention liability. So a question that arises here is how precisely to characterize this relaxed causal requirement. So Vladislava seems to conceptualize it as a departure from the counterfactual test, or departure from the but-for test, and that may be something that's in the judgments themselves. But it wasn't clear to me, though, whether that was necessarily the case. Another possibility might just be that the law in this context is just reducing the standard of proof on the but-for question and saying, instead of a balance of probabilities inquiry, the applicant simply needs to show that there's a substantial but less than 51% probability that the damage would not have occurred. which might help also to explain why liability in these cases still seems to be full liability. It's not liability in proportion to the chance. It might just be a sort of lowering of the standard of proof, but as a matter of substantive law, there's still a but-for test. I guess the test case would be if the defendant can show on an overwhelming probability basis that the outcome would have happened anyway. Does that have any impact on liability? If so, then it would just be a reduced standard of proof. If not, then something else is going on. A second set of comments then about what justifies this weaker standard of causation, however one characterizes it. So I think we can identify 3 arguments in chapter 3 for this weaker standard of causation. And I think it's fair to say that, so as Vladislava explained, the book's primary aim is descriptive analytical. So I wouldn't want to attribute the book as arguing necessarily for this weaker standard or saying it's absolutely justified, but I think there's an element of endorsement of this weaker standard as well in chapter 3. So I'm going to call them the conceptual argument, the demandingness argument, and the purposive argument. So the conceptual argument is that applying a but-for test is problematic because it would presuppose that the breach is the sole cause of the harm suffered. So Vladislava writes, such a proposal would be problematic since it would be based on the assumption that the cause of the harm is the state's omission, and the consequence of the omission is harm. And then a bit later, the omission by the state might be just one factor contributing to the occurrence of the harm, page 47. So this was interesting. I'm not entirely persuaded by this argument against but-for test. It seems to me that applying a but-for test does not itself entail that the state's breach would be the sole cause of the harm, but rather than a contributory cause. It seems that there can be multiple but-for causes or multiple but-for conditions of a single event. So if a parent and a nearby police officer both fail to intervene to help a child with drowning, both of those omissions could be but-for causes of the child's death. So the second argument is the demandingness argument, which is that, from the perspective of the victim, it's just too demanding to insist on a but-for standard on the balance of probabilities. So why exactly is that? So I think the answer can't be just that you're required to prove counterfactual. So it can't just be that you're required to show what would have happened. Some counterfactuals are really obvious. So if we ask counterfactually, if Roger Federer had been playing me in the Wimbledon 2019 final, who would have won? We all know the answer to that question. So some counterfactual questions are blindingly obvious, and some of them are really difficult. Is there something about positive obligations in particular which makes a hypothetical particularly difficult? Well, here I think there is something to be said for something that Vladislava says earlier in the book about positive obligations, which is that they are multiply realized. That there's various different ways in which one can perform to positive obligations. And so that might be a factor which makes it particularly difficult in the context of positive obligations to show what the lawful conduct on the part of the state would have been. If there's multiple possible lawful actions that could have been undertaken, and all of them were in conformity to the positive obligation, then there's a sense in which, in a positive obligation case, there's a sort of additional difficulty in proving that counterfactual question. Even that point, though, I think has a limited reach. In some cases, for example, in the breach of an operational positive duty to come to the assistance of a person under, say, Osman, it will be clear what measures ought to be taken. And so this multiple realizability point doesn't really have bite in those sorts of operational duty cases where it's going to be absolutely clear what should have been done in particular circumstances. So the police should have gotten medical assistance for a prisoner, or should have gotten medical assistance for someone who was dying. And so that there's only one possible way of complying with the positive obligation. More fundamentally, I think there's a sort of gap in this demandingness argument, which is that the fact that proof is demanding in and of itself doesn't seem like a complete reason for alleviating the burden of proof on a person. The fact that prosecutor's burden in a criminal case might be particularly demanding in and of itself doesn't give us a reason to alleviate that burden of proof. So that leads to a third argument, which I think we can identify in the chapter, which is the sort of purposive argument. So here the idea is that the aims of the ECHR will be better served by alleviating the burden of proof. So as Vladislav puts it, in the context of state responsibility, where the objective is to find the responsibility of the collective, strict causation lines are inappropriate. Yet one might still wonder why exactly it is about the context of state responsibility that merits this approach. To say that we're trying to define the responsibility of the collective might again leave a sense there's a bit of a gap here. We might say, well, we're only trying to find the collective responsible if it is responsible, and its responsibility depends upon causal responsibility. So if there's no causal link, we might say that collective responsibility is engaged. So it seems to me part of another strand of the justification might be simply that a false positive against the state, finding the state liable for a breach when it in fact hasn't caused the harm, is just less disvaluable and less disvalued than a false negative against an applicant. So failing to find the state liable for a breach when it has in fact done so. So in contrast to the normal position in private litigation, where we're dealing with two people who are going to be treated as normative equals, here that this default normative assumption just doesn't apply. We think, maybe weighting it slightly against the state isn't so problematic. So a false positive against the state in this context, where the false negative is not upholding a human right, is just less disvaluable. And so that would again tend to support the sort of standard of proof justification that, or conceptualization, we're just trying to tilting the scales slightly here and saying proof of a less than 50% probability is enough. Thirdly, moving on to avoidance techniques. So in an interesting section in the chapter, Vladislava considers ways in which the law could seek to avoid these complex causation questions, and thereby avoid this difficulty for applicants. And one such method is through redefining the relevant obligation, focusing on a sort of nearby, closely connected obligation. Procedural one is the one that's brought out in the chapter. So it struck me that this point could be generalized even further in some ways, in that in many cases it seems quite plausible to construe the relevant obligation correlative to the human right as an obligation to avoid creating, an obligation to avoid certain risks of harm. It's a sort of risk-based obligation. So simply by failing to protect a person from a risk, regardless of whether that risk materializes in harm, you might think can sometimes be a violation of the right itself. So if that's the characterization of the right, it's just a right not to have certain risks imposed upon you through culpable omissions, then the causal inquiry just isn't relevant to that right if it's construed in that way, and that wouldn't justify liability in respect of consequential losses, but you might think there's some justification for an award simply because that right's been violated. So what a common lawyer would call general damages just for the violation of a risk-based right. Finally, limits to liability beyond causation. In the final part of the chapter, it turns to limits which I think go beyond causation strictly speaking, but don't seem to concern other things like reasonableness or knowledge. So one of these is the requirement stated by the court in Lopez de Souza that the conduct must be systemic or structural, and thus not a mere error or medical negligence in medical context. But it also must implicate denial of immediate emergency care. So the question is, what's the rationale of this limitation? I think Vladislav suggests that a couple of things. One is that healthcare issues seem to raise more challenging issues related to allocation of resources and medical expertise. And secondly, that there are difficulties in establishing causal connections. The very difficulties of establishing causal connections might merit a focus upon systemic cases rather than incidental cases. To my mind, I thought potentially those considerations might point in the opposite direction, in the sense that complex allocative questions are more likely to arise, it seems to me, in relation to systemic failures compared to sort of incidental ones. And causal proof difficulties seem to me potentially even more stark in the context of systemic failures. So where, you know, the implementation of some general system for the prevention of harm might be expected to prevent harm overall in general. It might be very, very difficult to pinpoint in a specific case whether the preventative system would have actually benefited this particular applicant. So in those sort of systemic failure cases, it seems to me the causal difficulty could actually be quite, you know, quite stark and severe. So it does seem odd to think an incidental medical negligence case leading to death is a violation of one's human rights, but I mean, and again, I'm speaking as a total non-expert here, but it seems to me that if a single instance of a careless failure to investigate a threat to a person's life can amount to a violation of their human rights, it's kind of not obvious to me why a sort of single instance of medical negligence can also be said to death. I mean, as a matter of consistency between the cases in which you have a careless failure to investigate a person's a risk to a person's life. If a single instance of that that's not traceable to a systemic failure can amount to a violation of human rights, why not also a case, an incidental instance of medical negligence by a public doctor leading to the person's death? So I'll stop there. Thanks very much for an excellent book.
Wow, thank you. Thank you so much for those reflections. So I think we'll continue with you.
Yes, thank you. Thank you, because I do think also it was great. And I come to it from a different perspective as a public lawyer. So I didn't have such complex relationship problem causation, I suppose, because I did come to it thinking the duty of the state under a human rights instrument, which is scientifically bound, is to respect, protect, and preserve the rights under that convention. That's public law duty. And the problem arises often in relation to the polycentric nature of the duties of the state and the potential counter, that resource allocation problem we talked about, but also the competing rights of others which may be engaged. And I think that's really well in this book, the problem of state overreach, the problem of statism. So I think the rigorously approach is really great. I don't know if it's quite annoying or a tribute to the intellectual stimulation of the book, but I understand entirely why you, given the depth and richness of the case law, you focus on Articles 2, 3, and 8. But I kept wanting to broaden this out to particularly Article 4. I've done some work on positive obligations, but also the rights to forced labour, but also Article 10 and this conflicting obligations. How do you give people the right to impart ideas? What do you need? When actually some of the barriers that being heard are about failure to regulate the notion of public spaces. And the other angle that I came to this at, and maybe was like going off piece, was as somebody with a particular interest in equal protection of rights, or the duty to respect, protect, and fulfil rights under the convention. I think that necessarily imports quite a strong approach to positive obligations for weaker members of society, and otherwise fulfill their human rights in a way without the protections, because the state of nature will be going to struggle much more and the lifestyle can be nasty and brutish. So I think taking a positive approach to what's required to secure equal enjoyments of rights, such as rights to bodily integrity, Articles 3 or 8, or freedom from torture, broadening it out to freedom from forced labour, to freedom to voice your thoughts, that is inherent in Article 14. And that's something that isn't very much referred to in the case law. I was really pleased in the book to see references to Mayor Moldova, which was a case I did an intervention for the Rights Trust, and it was a 2 and 3 Osmond type case like domestic violence. But the court did imply that Article 14, I don't know if it's done it elsewhere, they wouldn't have done it since, but it did imply that Article 14 inherently created a positive obligation to protect domestic violence and had in place sufficiently rigorous prosecutorial systems, for example. And that's an interesting angle to the barriers to fulfilment of rights which others enjoy. And I also think it's necessary when, as is the case in more recent case law, Articles 3, 8 and 14, in the context of domestic violence, particularly gender-based violence, particularly, are implicitly interpreted in line with the Istanbul Convention. Raising poverty and violence, or recent instruments like the UN Convention on Rights. So I think that's just an interesting angle on it. And also in relation to, for example, Article 8 and safety online and online harms, especially against online children, women and children as well, much better on. So I think the reality is that we need a strong approach to positive obligations. But the reason I think it's really important that we've tried to take such a rigorous approach to conceptualising when positive obligation arises, the extent of such an obligation, demarcation, is because often, because what positive obligation is trying to do is stop harm that will otherwise happen from the actions of third parties. They always, unlike private law tort, you've always got at least two causes, because you're talking about the obligation to protect someone from something that otherwise occurs. I think because of the potentially infinite nature of the steps which could be taken to stop the harm, and the very fact of different traditions and different societies, that's what makes the steps that it's reasonable for international human rights oversight mechanism like the European Court of Human Rights to say are positively required to be taken. Failure to take those steps is a breach of the right. The convention of duty of the states undertaken is a very complex and a political one. You mentioned the problem of children in care. We have the problem of taking children away from parents when we shouldn't have done. Failure, of course, probably to investigate the breaches you could impose on someone's private life and their life to enjoy a family life, which you university take someone into care. Equally, you've got the problem of if you don't take someone into care, well, they're going to be hurt, tortured, killed. So, there's a limit to what a court can say should have been done in those complex judgment form cases. And I thought also, I can see this as maybe in cases coming to the court's hand. I can see that argument in relation to COVID responses. Danger of state overreach, limited freedom as against the only of the state to protect people from harms or something not otherwise not to suffer. So it is really conceptually difficult to identify the ambit of positive obligation. But I suppose there is the difference between known and unknowns, and when you can say this is something we should have anticipated, we should have at least had a process to look at this, to take some sort of steps to mitigate against it. The other problem, I think, as a public lawyer, I see with the state trying to, like the court, trying to grapple with the concept of the extent of a positive obligation, is that we are in a period of really heightened nationalist sentiment. I don't think that's in this country alone, but it is in this country. And I think that means that the court is wary, probably rightly wary, of questions of democratic legitimacy and the extent to which it is appropriate for the European Court of Human Rights, which isn't a court of capturing ourselves, to say what the state should have done to avoid a harm which is ultimately caused by a third party, rather than examining the legality of an act commissioned by the state itself. And I think the problem with some medical negligence is probably dealt with by the fact that the court will come to it as procedural domestic remedies for most countries. It's been an act of negligence. Domestic court should have decided that all in the first place and has an effective remedy step. Damages for that should be in the court, but technically, what is a breach of human rights to what does that add to the harm domestic law limited for it, but I can see the context of taking that. does still need to be bottomed out. But I do think that question of legitimacy and the extent to which it's appropriate for court to articulate what a state should do, especially in cases of competing resource allocation, is one that makes it very difficult to give an extensive articulation of the positive legal duties of the court. And I think that's why it's right that you emphasise really throughout the importance of the reasonableness standard. Probably also this being an area where I think the European Court is particularly sensitive to the concept of margin appreciation limits to our international court. Because I do think there's a real danger if the European Court of Human Rights goes too far in articulating a particular set which as a matter of law, international legal obligation should be taken or won't take it, does increase the backlash, the risk of backlash against the idea of accountability by standards at all. I think that's something that's being sensitive to the normative content of the rights that they seek to enforce. And so I think it is real strength and utility that it does take a careful, structured approach to try to bottom out the principles that the court is trying to apply and the extent to which it does that in a consistent and analytical way, and to extent the knowledge or imputed knowledge which triggers positive obligation, concept of causation of harm in this very difficult context, and the international nature of the test that the court is trying to apply in relation to reasonableness, balance, rights. And I was particularly interested because I think that this is where the court really needs to be, at your analysis of positive procedural obligations, duty of the court to have thought about what is a foreseeable risk and what's an unforeseeable risk. Many of us could be suddenly knocked over the head by a maniac walking down the street, but if you've got someone who is crossed the lines of the authorities in relation to domestic violence, Osmond-like case, they should have known about this person and exist. Then what as an actual procedure should be in place to identify the harm, to assess the risk of harm, to put in place steps you may never put in place. What's the reasonable thing to be done in a framework to anticipate and foresee and where possible to restore harms. And whether that is conceptually different from the duty to operationalise such a framework. It's okay just to have such a framework in place where perhaps you might have taken a different view, but you didn't know what particular steps to take in that context. And I suppose that is where the difference between public law obligation to consider considerations and a tort model. I just find that public law approach to it attractive. That's my training and my way of thinking about things. But the other way that I think in relation to positive obligations, we do have some problems is in relation to the concept of a victim in Strasbourg case law. Because in some contexts, courts take a very wide approach to a potential victim, I think abduction in particular, if you have a law that criminalises homosexuality, then it's a risk to someone who is gay that they may be criminalised, that engages state's responsibility to that person rather than waiting until somebody has actually arrested them. What happens if you know that a particular person or a particular group is particularly vulnerable to a special kind of harm? Do they become a victim even though they haven't suffered that harm? Because in a public context, they probably would have standing to bring a claim, but it's probably a higher standard of victim, which if you're seeking to get damages about, damages for breach of positive obligation because the court doesn't deal with theoretical questions. So I think that's an interesting area about maybe where that's the question of pursuability. I am a member of this group. You should have thought about members of this group, because you should know if you're trying to enforce your duty under Article 14, secure equal enjoyment of convention rights. this is a really particular vulnerable identified place where we protect the from, say, on harm or particular form of violence. And therefore, a person then does that and say, you should have thought about this, you failed to think about it, and therefore I am victim of harm. So, yeah, in the domestic context, things like public safety property duty and the idea of anticipating potential harms or breaches of what we could do, and the link between that failure to anticipate and then a private resource actually that results in it's a really interesting book. Sorry to say that it's really interesting to know about in your class, but it's set up on lots of food for thought.
Thank you very much, Ed. Thank you for
Thank you. Thank you very much indeed for the opportunity to be here, and many congratulations on the book, which is fantastic. The depth of its analysis is just most impressive, and we've heard a very rich analysis of it already. So I want to just say offer a few reflections, first some general observations on the importance of this case law, then turn to some of the UK Ministry of Justice's approaches or reflections on possible obligations in a kind of provocative way for us to think about that. And I'll wrap up by saying something about COVID-19 in this context. And I was going to say something about extraterritorial obligations, but I'll limit that given time. So the general observations, I think we should stand back and reflect on how important this whole line of case law is in terms of transforming probably our whole understanding of what human rights are. I have a quote here from the 1970s from a Greek judge on the court, Judge Epigenes, who was referring to the, quote, change in the legal content and function of basic rights, the 1970s, required to reflect a change in social realities. And he was advocating, therefore, he was writing extrajudicially, a more advanced approach to human rights, modern human rights legislation, increasingly relying on the concept of the state conferring benefits. And there was elements to this positive obligation case law in the case law of the 1970s, in the case of France, Belgium, and Erie and Ireland. But of course, the area you were focusing on especially was blossoming from the late 1970s, 1990s onwards. The Osman case, one leads on above all. Positive obligations that may arise from omissions from the state in particular. So I look back at the Osman case and was interested to see a certain passage in it in which it referred to certain, quote, certain and well-defined circumstances where exceptionally the state is required to take positive steps to protect lives. So the court was alert very early on in its very first case in this field, Article 2 at least, that it was the need to tread carefully. And as you had quotations on screen, highlighting the court's very conscious at the beginning that the duty should not be interpreted in a way that imposed disproportionate burdens, etc., or impossible realities on the state. Then focusing on the Article 2 case law alone and how that's blossomed, just therefore to underline the importance of this case law, has the court kept it within those certain and well-defined circumstances? I think generally speaking it has. I was trying to reflect on that Article 2 case law. You can see it under two broad heads. This is just Article 2. Circumstances where the state assumes responsibility for the safety of individuals, prison contexts, if you like, mental health legislation cases, etc. More broader circumstances, states where the state has become aware of dangerous situations, and that's the environmental health type cases, isn't it? And unlawful acts of violence from others, Osman classically, appalling conditions in residential care, etc. We see through that case law the real importance of this line of case law. And that's where I turn then to some comments which are deliberately provocative in terms of how the UK government, actually at least the Ministry of Justice when it was under Dominic Raab's leadership has looked at positive obligations. And it reflects the kind of backlash in keeping with some of the comments you were, or thoughts you were having there, of how there could be sensitivity to the notion that the court is asking too much of states. But I'm not saying that is what the court is doing. So just to offer some insights into the type of criticisms which I'm not advocating that the Ministry of Justice was putting forward in its consultation on human rights reform of a couple of years ago, it seemed to be preoccupied with the creativeness of the court in this field and the living instrument approach being a bad thing, and going counter to that point that the court was saying in Osman about not imposing disproportionate burden, suggesting that the court was indeed doing that, and referring to, quote, claims of considerable legal uncertainty arising in this field. Your book is a really good retort to that. Well, it identifies areas of legal uncertainty. It's great in your book that it's actually putting this area of law under such a microscope. Because I think my more general point about the Ministry of Justice's consultation here and other matters would be actually how sweeping and general its comments were, lacking in evidential base. The court refers to the Ministry of Justice referred to the expansion of positive obligations, quote, stemming from the Strasbourg court is one reason why many questions of public policy have come to be decided by the courts rather than Parliament. That's another dynamic to what was going on in this sweeping characterization of possible obligations, which is misunderstood, I think, but leads to this suggestion that it's actually imposing disproportionate burdens on the state, which I'm not saying is the case. So in that, part of the Ministry of Justice's, if you like, attack on possible obligations, it referred to, for example, the Osman case, and came up with very generalised figures relating to how this had apparently put disproportionate burdens on Manchester police and in relation to threats to life notifications. But what really emerged from this, and then we saw this then in the Joint Committee on Human Rights report, parliamentary committee's report, following up on the Ministry of Justice consultation, was how the evidence base that the Ministry of Justice had was well, not very well-founded and was somewhat flawed. So to quote from the now the Parliamentary Committee, the Joint Committee on Human Rights report, it's countering the possible obligations narrative as set forward by the Ministry of Justice, quote, whilst resources of public authorities are a legitimate concern, the government has not provided any evidence the resource burden on public authorities as a direct result of their positive obligations under the ECHR. The government cites the burden of issuing threat to life notices, but does not provide any data to demonstrate the evidence base for these concerns. Further, the Strasbourg court is cognizant of resource pressures on public authorities and explicitly acknowledges this in its case law. So we had a good retort there from the Specialist Committee in Parliament on the need for evidence base in relation to what could otherwise be sweeping and were continually sweeping accusations. The report, the Joint Committee on Human Rights report, went on to actually highlight its evidence that it had taken from Lord Wolfson, who was then one of the ministerial team advocating reform in this field, and pointed out actually that in his evidence, it emerged that the problem it seemed that the UK government at that point had with possible obligations case law was that the genesis of the obligation should come from the Strasbourg jurisprudence rather than UK sources. So unfortunately, there was this kind of anti-European narrative for what was going on. The government proceeded nonetheless with its proposals to change the law on positive obligations and more generally in relation to the British Bill of Rights, notwithstanding a wealth of responses from civil society saying that this would not be a good move. I'm trying to find the figures here. In terms of people, civil society organisations, groups that submitted to the consultation which the Ministry of Justice had put forward, there were around 1,600 respondents who noted that no change was required to the current framework on positive obligations. nearly 1,300 respondents mentioned that they believe positive obligations provided protection for vulnerable people, and nearly 900 respondents considered that this was not a genuine issue at all, that which the government was claiming that positive obligations were problematic. So, general comments that I think could be made about the government's approach there are really how uninformed it was, and how reassuring it was to see that civil society and parliamentary groups were able to push back on it, with some success it seems, because, as I expect we will know, the government is not progressing forward with its Bill of Rights bill, happily shelved a year or so ago. But it really underlines the importance of your work, if I may say so, because your work offers this penetrating analysis of Strasbourg's jurisprudence, highlighting the scope and nature of positive obligations, and highlighting that criticisms can be made of the Strasbourg jurisprudence. But we see there a careful, reflective approach to that jurisprudence, rather than, if I may say so, the kind of knee-jerk response that I think we were seeing the UK Ministry of Justice's approach. So I welcome it very much indeed from that perspective, especially. Thank you. I said I wanted to offer, just to broaden out the discussion, some reflections on COVID-19 and positive obligations, which of course you would not have had a chance to really advocate in identifying your book. Although I note you say in the preface that, of course, it was written during the pandemic when COVID-19 was no doubt being an obstacle to your progressing. Well, actually, what surprised me about it, I tried to look up case law on COVID-19, and there seems to be, in the UK context, remarkably little on it. It's an area in which one would expect there to be more, perhaps. Now, the sense I got from that, looking actually to joint parliamentary committee reports on the government's response to COVID-19, was the importance of the principles of the Strasbourg case law in relation especially to Article 2 on positive obligations. One can think there in terms of provision of protective equipment, for example, but then a lack that I'm aware of, at least, of any real case law that's followed that up. That may, and I'm wondering about it. But there is a case called Gardner, a High Court case, which was potentially raising an issue to do with Article 2 positive obligations about care homes, the early days of the pandemic, when asymptomatic patients were released into care homes and evidently spread the virus, causing many deaths. And in that case, perhaps surprisingly, I don't know, we may want to discuss it, the court actually said that Article 2 positive obligations didn't apply at all. It was not able to find any Strasbourg jurisprudence for the proposition that preventing the spread of a pandemic would trigger a positive obligation in that context. I found that a little surprising, though perhaps I need to read the case a little more carefully to understand it. So a general reflection I have there is, does the positive obligation promise much but not deliver as much as we would hope it to? Or could the reflection be actually that positive obligation case law, which we all welcome, I think, is doing a very good job in terms of putting aside the Gardner case, in which a public law case in which the government was held to have violated public law in a different way. But perhaps still that the messages of positive obligations are now being obeyed by decision makers or adhered to by decision makers in a very good way, such that they don't always need to be leading to violations of the convention. And I think that will come through in the Joint Committee on Human Rights report of 2020. Look, I think I should stop there, other than to say this general point, how much I very much welcome your book. And I think it should be a positive obligation on decision makers in the UK, particularly the Ministry of Justice, to read. Thank you very much indeed.
Thank you, Adam. And as we said, because it's open access, it would be easier to read it as well. So this is the moment in our format, Vladislava, where you are given the possible task of very briefly responding to your commentators, which actually does mean very briefly, because you've received quite a lot of rich comments. So we'd love to hear from you, because just after that, I'd like to also for questions from you.
Just a few important reactions. So when you started with the statement that public works have no complex relationship with the standard of causation. Now, I know that there are other human rights lawyers, but I would say that we human rights lawyers, we have no relationship with causation whatsoever to that point. When I started looking at causation in human rights law topic, I would say how causation exactly is approached. So in this sense, it's an area, but because causation, and this goes back to the purpose of human rights law. So let's say in private law, causation is so important, which is related to the purpose of that area of law, which is compensation, which is money. At the end of the day, while in human rights law, it's as I said, the responsibility of the collective, and this relates also to the constitutional role of the European Court of Human Rights to set certain general standards that all states will follow. But yeah, I don't think that human rights don't have any relationship with causation. So in this sense, it's the most difficult way to respond to your comments. Since I have to be brief, now, COVID-19, just thinking of what's easier for me, there are actually many pending cases before the European Court of Human Rights related to COVID-19. Most of them are about breaches of negative obligations, not about positive obligations, which I think that is very important because if there is some indication there that the state might have done too much, actually. And at least this is the review that they did a couple of months ago of any cases related to COVID-19. As to the positive obligation of preventing the spread of the pandemic, there is a relevant case of which others, which is the vaccination, the component vaccination case, where the court referred to this aspect of positive obligation of protecting the public. So this would be relevant here. I don't know how brief I should be.
You're doing really well. So
Okay.
a little bit more.
Yes, also the uncertainty and all the backlash that you mentioned, and then also mentioned the backlash against these positive obligations. And so when my approach was the following, going back in time, because historically human rights law was meant to limit the state. Then there was a realization that, well, that not enough, which relates to the transformation of human rights law, is in a way supporting that idea that actually the state should be, the power of the state should be harnessed so that harm is prevented and people are protected, which is in a way a positive development. And my understanding of the existing discourse of scholarship in the area of human rights law is that this has been always very positively accepted. Development of positive relations has been always, at least the human rights expert, endorsed. What I wanted to do is to also say, well, okay, but there are also certain risks here and certain dangers, and this was one of the objectives of the book. So let's look at this other side, and more specifically, let's look at the case of European Court of Human Rights. And after looking at the case of what I can conclude that the court is extremely sensitive to this other side, to those risks and dangers. You can call it regulatory overreach or too much state. I think that the court is sensitive to this. And in some cases, the court, for example, clearly identified competing negative obligations, competing positive obligations. And it in the reasoning, it should continue actually to identify those competing interests and competing obligations to show that sensitivity. So this was positive that the court shows sensitivity, and as I see the case law at this stage, I wouldn't say that the court has gone too far in its development. It has shown sensitivity to the other side of positive obligations. Yes, absolute uncertainty. There is, and during my presentation, I said, well, there's a lot of obscurity on this point, a lot of obscurity on that point. There seems to be a lot of uncertainty, but it actually goes back to human rights law. So rights are the organizing principles, and how rights generate obligations is quite complex. So there is uncertainty as to the obligation that comes from the right, and this is unavoidable, and it's in the context of negative and the context of positive obligations. The same thing, but because the right are the organizing principles, not obligations. Although you mentioned the Istanbul Convention, what development that we saw is that decades of case law, the European Court of Human Rights in the area of domestic violence, so in a way kind of codified in that convention, and the specificities of the obligations developed by the court were then used in the drafting of the Istanbul Convention, which was very positive. But at the end of the day, how human rights generate obligations, the scope and the content of these obligations, it's incurrently, this uncertainty is unavoidable. Yeah.
All right, thanks. Thanks so much. So I'm very happy to open the floor for comments and questions. And